Okay, everybody, we're going to talk about the 1900s in this lecture. During the 1900s, we started to see kind of the rise of the new industrial elites. Remember, we went from an agricultural society to more of an industrialized society. So we saw the first generation of U.S. capitalists who really had not much sense of public responsibility. You know, they believed really in social Darwinism, which is kind of the survival of the fittest, and there wasn't really any protections in place. And when you kind of look at business and look at the fact of how much government should be involved in business, it's going to be some differing opinions. Many on the left may feel that business should be really controlled by regulation and government, and those on the right may say that there's might be too much regulation and it hampers innovation and all that stuff. So we'll kind of think about that and keep that in mind while we're going through this. So the Bessemer process was a process where they were able to convert iron into steel, and it made Carnegie a millionaire. But it also helped transform American life by building railroad tracks so we can move commerce, plows for farms, bridges, the first skyscrapers, scalpels for surgeries, sewing machines, and automobiles. By the 1880s, the value of manufactured goods surpassed that of farm products. So now, like I said, we could see that we're going from an agricultural society to an industrialized society. And you can see on the screen here that there were a lot of investments that happened, and investments increased almost tenfold in 40 years. All right. So let's go and look at this. We also see aspects of the development of the railroad system here. Mileage increase, the square mileage increase. So that gives the fact that you can not only move people, but you can also move commerce now, which I think is a very important thing. So we also saw mergers, and a lot of these mergers have come across where maybe competition was reduced in some industries. We saw the building of modern corporations, which is an integral part of what we call the Industrial Revolution. We also started to see education take precedent here in the United States. The literacy rate jumped, and we saw more people going to school and more people becoming educated. Also, we started to see more mergers, and the United States Steel Corporation brought together 158 companies to kind of form a conglomerate with a capitalization of $1.4 billion, meaning that's what the company was worth. And also, all this led to the growth of cities and urban areas. Remember, we didn't have that much reliable transportation at the time, so people had to live close to their work so they could walk. By the 1900s, about 9/10 of all manufacturing took place in cities, and it dominated the nation's economic, political, and cultural life. And this is where we also started to see the development of the middle class. With that being said, about 60% of the population's nations of the nation's 12 largest cities were composed of foreign-born people or their children, and many immigrants immigrated to the U.S. because they became a source of cheap labor. We also saw juvenile delinquency and crime were rampant. Obviously, disease and death were constant. We didn't have the medication that we have now. We didn't have the vaccinations that we have now. And the infant mortality rate was relatively high, especially as you can see on the graphic here in Chicago, where 3 of every 5 babies died before their first birthday. We also saw kind of a laissez-faire type of economics, and this is derived from Adam Smith, who was an economist who looked at kind of what's called the invisible hand theory, where you let the government take their hands off the economy and let the economy naturally guide itself. Now, again, kind of going back to a point I made earlier where I said there might be a differencing of opinion where on how people feel about how much government should be in business. This is also kind of prevalent because in laissez-faire economics, the belief is that there should be little to no government inside business. And again, it's really based off of your ideological belief. Now, if you ask me personally, I think at the very minimum, the government needs to regulate business as far as consumer protection, meaning that if we go out and buy a car, we should expect it to work the next day and not get ripped off. I heard a story from a friend of mine. I don't know how much it's true, but I would be pretty upset if this happened to me. I bought a Tesla for $50,000, and the battery failed, and it was no longer under warranty. And I didn't know how. I didn't ask him how old the car was, so I'll ask him next time I see him. And he said it cost $25,000 to replace the battery because it's a special battery, obviously. So if that was me, I'd be pretty upset because I wouldn't feel like I would be protected as a consumer. And I asked him if he had a warranty, and he said no. And it's a little odd because when I got my car, I had a warranty on it. So it's just kind of those things I think we need to protect it against. Also, there needs to be safety in the workplace, and the worker needs to be protected and not doing too dangerous jobs that might hurt them. The gap between the rich and the poor expanded during this time. We saw the rich get richer and the poor got poorer, and 1% of the population owned most of the wealth. And that's something that is kind of consistent of what we see here in the United States now. Our working conditions were bad. We had 60-hour work weeks. In comparison to now, we usually have a 40-hour work week. 1 million people suffered some type of industrial accident. Remember, there was no workers' comp insurance at the time, no OSHA, which is the Occupational Safety and Hazard Administration. We had children working. About 1.7 million children under the age of 16 worked full time, 12 hours a day for an average of 12 cents a day. So, you can kind of see that maybe they were being abused, and unions were not very effective at this time. The American Federation of Labor began to gain some power, but only 12% of the workforce belonged to a union. And that is kind of analogous to what we have now, where we have about 12 to 13% of workers in the United States are unionized now. And we'll kind of talk about that as we go along. Women were not so much in the workforce. We had 20% of all women over the age of 15 were employed. There was a code of conduct for women. Women were supposed to be subordinate and ignored, cold and passive. Giving birth control advice was illegal and immoral. And we're going to actually see a case later in the term where we see a person getting arrested for providing family planning advice to a married couple. Southern blacks were still subject to arrest at the whim of law enforcement. Even though we had the Slavery Amendment and the Equal Protection Amendment and the voting amendments, they were not really being enforced. And African Americans were still disenfranchised, even though we had these constitutional amendments that were passed, and it still looked at African Americans as a second-class citizen. And the reason that this happened was people weren't doing their job. People weren't enforcing the law, especially in the South. Violence of the blacks was commonplace. We saw lynchings, and it's kind of disappointing that, just recently lynching became a federal crime and, a hate crime, which is totally ridiculous because, we've gone, 100 and something years where, it was a crime, but it wasn't treated as serious as it should be. So the good news is now it's a federal crime. And if there's a case where somebody's lynched, it's going to be done in federal court. Obviously, Native Americans were impoverished, disenfranchised, their land taken, their land colonized, disease passed on to them, culture being killed off, and Native Americans first got the vote in 1924, which is another ridiculous thing that we've had here in American history. Mexicans, we had about 100,000 people of Mexican birth living in California in the Southwest by 1900. Scorned for their culture, the Catholic religion, the language, and exploited by employers who were eager for cheap labor and shunned in the slums. We also saw the spoil system or patronage. That's another term that we're going to use in this. The spoil system was where, say, for instance, I was running for mayor and you were all my supporters, right? And in exchange for supporting me, I would give you a job in the government once I become elected to mayor. But then again, you're going to have to kick back 15% of your salary to me so I can put it into my party coffer so I could use it for re-election time. So just think about that. That's totally illegal now, and we'll look at systems of why when we get into the progressive era and how there's things that are done to prevent patronage. I used to work in county government, and it took me a good year to get hired there. And, going through an application process, going through a background check, before that, an interview, answering supplemental questions. So these are all things that have been put into place to kind of assist governments in preventing patronage. Now, does this still happen every so often? I imagine so, but there are systems in place that try to prevent it. We also had election fraud that was common. In Indiana, for example, people would bring in voters. Illegal votes were imported. Ballot boxes were stuffed, and African Americans were cut from the polls by intimidation and violence. Then we went into the progressive era. We're going to take a look at the progressive era in another lecture, and it was kind of reforms that were trying to get rid of laissez-faire economics and social Darwinism, and really sought to bring better treatment of people here in the United States, and we'll address that in another video. Okay, thank you. Go forward and look a little bit more at the progressive era in another slide show, so that'll be added to after. That'll be sent as a separate video. So we came up through the 1900s. We'll talk about the progressive era in another video, but for this time we're going to talk a little bit about federalism. So we're going to explain the basis of American federalism here. We're going to talk about the necessary and proper clause and how it relates to American federalism. Then we're going to analyze different periods of federalism in American history. So federalism is an issue or a system of government where you have the same territory that could be controlled by two or more levels of government. In the United States, we have federal, state, and local governments, and they all have powers. The federal government has some very specific powers that are delegated to them through the Constitution. These are going to be called enumerated powers or delegated powers, right? So we can all maybe take a look at this, and we see federal, state, and local, and they kind of act independently, but with some pressure from the federal government at times, and we'll look at some of the things such as mandates and stuff like that. So we look at a few of our enumerated powers in the Constitution, things like laying taxes, punishing piracy and felonies on high seas and offenses against the laws of the nation, regulate commerce, coin money, establish a post office, a lot of the stuff that we talked about last week. The state responsibilities here in the in California, and we'll use California as an example, are to conduct elections. The Secretary of State here in California will set up the elections, and they will give kind of a little bit of guidance to the local governments to run the elections. We have a registrar of voters in each county, and they are the ones that will run the elections here. They can lay taxes. They can help run federal programs like unemployment. Unemployment is a federal program that is also administered by the state using federal tax dollars as well as state tax dollars. And it's a thing. If you lose your job by no fault of your own, you can apply for unemployment and get paid. I think the max is $450 a week. But that money comes from taxation. Medi-Cal, which is a low-income health insurance, is the same. The federal government, along with the state, will contribute to a fund to run the Medi-Cal system, and the state will put in the requirements, and they'll push the duties of eligibility determination and enrollment onto local governments. So if you ever needed to go and get apply for Medi-Cal, you would do it online, and I think you go to one of the county offices to kind of have your interview. CalFresh is also more commonly known as food stamps or EBT. Again, this is federal dollars used. You go to the county and apply for it, run through the state. They also run schools, motor vehicle registration, and the courts. Remember, we're going to have two clearly defined court systems. We're going to have the federal court system and the state court system, and we're going to get into a discussion of that and talk about that a little bit more later in the class. If we look at local government duties, a lot of local governments are responsible for parks and rec, police and fire. So, local government will provide police protection as well as fire protection. And I kind of glossed over parks and rec. They will, kind of run the parks system and recreational programs, which are vital here for young people and for maybe people that want to do some type of activity. They also get engaged in housing services, emergency medical services. So the city of San Diego will engage in a contract with an ambulance company to provide, ambulance services. Transportation, that could be something like buses and trolleys. Some cities in different parts of the county of San Diego will have their own mass transit system, and we obviously have the trolley in some parts of San Diego, and public works. So if there is a pothole that needs to be filled, or if there's like some type of problem with the sewer system, the county public works department will handle it. So we look at this as a real world example. We have the federal government, the state government, and local government. Under local government, we have county, city, and smaller municipal governments like school boards and stuff like that, right? Now, when we talk about, kind of confidence in state and local government, at times people will have more trust in local government and state government than in the federal government. And we can see the numbers here. And why is that so? I think, it's easier to kind of recognize the fact that local government officials might be easier to access than maybe a state government official or a federal government official. If I go down to, I live in Chula Vista, if I go to the city of Chula Vista and try to talk to my council person there, if they're there, it might be a high probability that I could go and see them, right? Or talk to them personally. They're in our community, and they usually campaign, and they're present in the community, whether that's at some type of maybe memorial or some type of dedication or whatever. State government and local governments are a little bit different. They're a lot more harder to access. So I think that's probably one of the main reasons that local government is viewed more favorably, right? There are more than 86,000 types of government here in the U.S., and most of them are going to be on the local level. Like I said, school boards, water districts, city councils, board of supervisors. So when we kind of talk about federal power, the constitutional power and federal and state authority, the Constitution lists 18 specific powers that are delegated to Congress. And states and local governments can't engage in those powers, right? If you click on that link that I have right here, you could go ahead and see what the delegated powers are. I'm not going to go over them because I don't expect you to know every single one. We went over a handful. There's going to be 18. Among that 18 is something called the Necessary and Proper Clause that we'll talk about. For the most part, by the 10th Amendment, states and local governments can make laws as long as they don't conflict with our individual rights. Now, can these laws conflict with state law? Can state laws conflict with federal laws? Yes, and we'll talk about that in a minute. So the 10th Amendment, which is the final amendment in the Bill of Rights, gives powers not delegated to the United States by the Constitution, nor prohibited to it by the states, are reserved to the states respectively or to the people. What this basically means is that states can pass laws separate from the federal government as long as they do not violate the Constitution. But if a federal law and a state law conflict, federal law will trump state law. This is due to that supremacy clause in the Constitution that we talked about last week. Article 6, paragraph 2 is simply referred to as the supremacy clause, meaning that our Constitution and our federal law will take precedent over state laws and even state constitutions. If we look at a real-world example, Prop 64 in 2016 legalized marijuana or cannabis for recreational use. Currently, marijuana is illegal under the federal law. There is something called the Controlled Substance Act of 1970, which was passed by the Nixon administration, which put marijuana as a Scheduled I narcotic. If the government wanted to come in and shut down all of the dispensaries in California, arrest all the growers, and arrest maybe the people working at the dispensaries as distributors, uh, they could possibly do that because federal law trumps state law. Now, are they going to do that? I don't think so. I really doubt. I think they would have done it by now already. But remember, marijuana is still a Scheduled 1 drug federally, so federal law outweighs state law. So in a sense, marijuana is still illegal at the federal level. But since we have the 10th Amendment in this, California can have this, which is voted based off of an initiative that we saw in last class. It is certainly within the power of the federal government to come in and shut down the dispensaries. It's just a matter of will they do it or not. And both the Obama administration and the Trump administration have not done that, and I don't think Biden's administration will do it either, because I think Biden is, and there's a lot of thought in the federal system that we need to decriminalize cannabis as well. But we'll see where that goes. As part of the powers that Congress has, one of the other powers is the necessary and proper clause, right? And this came out of a case called McCulloch versus Maryland, where the court gave Congress the power to expand their powers to include maybe something that is implied, an implied power that might help them accomplish one of the enumerated powers. And we'll talk about that in a little bit. But this came out of an issue where we had a court case where the state of Maryland tried to charge the federal government $400,000 in taxes to run a bank in there. But since it was found that creating a banking system even though it had not been expressly enumerated in the Constitution, it still fell within Congress's implied powers. So we look at the necessary and proper clause that says to make all laws which shall be necessary and proper for carrying into execution the foregoing powers and all powers vested by this Constitution in the government of the United States or department or officer thereof. So basically, if a government can fit something, if the government is going to pass a law that's not specifically mentioned in the Constitution, can Congress do that? Yes, if they can rationalize that what they are doing is to execute one of those delegated powers. Problem is, these enumerated powers are really broad, so you can pretty much fit anything into it. So Congress has a federal statute that issues a tax. Congress can do that because taxing is a enumerated power. Federal spending, yes, enumerated power. When enumerated power isn't enough to validate a law as constitutional, Congress can add that elastic clause or that necessary and proper clause can be used to broaden Congress's authority to enact a law. And we're going to look at a real world scenario in a minute. But as part of this, in order to be able to use the necessary and proper clause, you have to be able to justify the means of the goal, right? And it kind of goes in conjunction with that classic Machiavellian type thought where the ends must justify the means, right? So your end game in the law that you are trying to pass has to justify that goal, right? It can be used as a broader authority to enact the law so long as the means reasonably relate to an end. So your ends must justify your means, right? And there's a case called U.S. versus Comstock where I think it was one of the more interesting cases that this was determined to be appropriate. So I don't know if some of you guys may be younger than or I know a lot of you are younger than I am. There's a gentleman named John Walsh who used to have a TV program called America's Most Wanted. I don't know if it's still on. I still think he does stuff for victims' rights. But his son Adam was murdered by a repeat offender, right? And on the 25th anniversary of Adam's death, Congress passed the Child Protection and Safety Act. And what this did was it organized sex offenders into 3 tiers, where Tier 3 was the more serious, then Tier 2, and then Tier 1. This required states to comply with the statutory scheme under which states are required to modify their registrations in accordance with federal requirements. So states had to adopt this as well through a directive from the federal government. And if you go here in California, there's a website called Megan's Law. And if you look on Megan's Law, there's going to be a listing. And if you check your address, there's going to be a listing of potential offenders that live in your area because they're required to register. And if states did not implement this system, that was in compliance with the federal law, with the Adam Walsh Child Safety and Protection Act, they would risk losing 10% of their law enforcement assistance funds that are given by the federal government. So you can also see that there is a bit of coercive federalism here, which a term will address in a few minutes. One of the more controversial parts of this law is that this law also gave the federal government the authority to hold someone accused of child molestation past their release date if the feds still believe that their person is a danger to society. So federal law allows the courts to order the civil commitment of a mentally ill, sexually dangerous federal prisoner beyond the date they would have been released. And this is 18 United States Code Section 4248. What does this all mean? If a judge has an inkling that somebody has engaged or attempted to engage in a sexually violent conduct or child molestation in the past, if they suffer from serious mental illness, abnormality, or disorder, and as a result would have difficulty refraining from acting out on that, they could be civilly committed, even if their sentencing date is up. So say there is a person that is put in prison for 5 years. If when that 5-year release date comes up, if the judge, along with medical professionals, feel that that person is not suitable for release, they can still civilly commit them. There is due process according to this. A hearing is available to the involuntarily committed individual every 6 months, where a psychiatrist and a judge get together and discuss whether or not this person is rehabilitated more. And if they haven't, they'll still be kept in custody. Graydon Comstock had finished his sentence and was to be released. He was incarcerated for 3 years following a conviction of possession of child pornography. He was not released as he was civilly committed and still considered a danger to society. He argued that that law violated his constitutional rights, and the Supreme Court found that the Congress did not exceed their power due to that necessary and proper clause. In a 7-2 vote, Clarence Thomas, and Anton Scalia, who is no longer with us, both dissented. The question was, and what does this have to do with federalism? Does Section 4248 infringe on state police powers? It was found that it didn't, because state police powers is a source that is derived from the 10th Amendment, which reserves all powers not expressly delegated to the federal government for the states. The United States argued that Section 4248 doesn't infringe on states' police powers because these people are already in custody. They're already in federal custody anyway. So we talk about the legal reasoning in this. It was just a rationally related and reasonably adapted law that helped execute one of those enumerated powers. And if we go back, let's see right here. Right here, this is the enumerated power that it was found to fall under. Offenses against the law of nations. So let's go back. So I think this is a really interesting case. Now let's kind of talk about the evolution of federalism here in the United States. Now, if we talk about dual federalism, we've seen that in a period from 1791 to 1901. This was called layer cake federalism, and we'll look at the differences of this. During the first 110 years or so of our nation, states and federal government shared powers, divided most powers. The national government would concentrate on those delegated powers that we looked at, and states would decide the more important domestic policy issues. Now, we also have something called cooperative federalism that happened from 1901 to 1969. Marble cake federalism, right? Both the nation and the states exercise responsibility for welfare, social welfare, public health, highways, education, and criminal justice. The federal government will provide grant and aids to help states run, policing, education, and they'll kind of also work together with things like highways, right? Or freeways. An example of cooperative federalism is that the federal government will get tax revenue from all of us and give it to states to fund interstate highways, right? The states, and we'll use California as an example. California has Caltrans, which kind of oversees the maintenance and the construction of freeways. So if there's an interstate that passes through multiple states, the federal government will fund any repairs or anything that needs to be maybe added to those freeways or interstates. But they'll have the states do the work. And here in California, it is called Caltrans. So looking at this, you could see the difference seen in layer cake federalism versus marble cake. Layer cakes, we have programs and authorities that are clearly divided between the nation, state, and local governments. And then on the right, we have marble cake federalism, where we have a mixture between the national, state, and local governments and how their programs and authorities are mixed. Kind of past that, then we started to see the evolution of a new type of federalism, where a lot of our problems that we had at the time were declared to be national problems, like the war on crime, the war on poverty, the war on drugs. So, kind of coming out of, the New Deal era and the Great Society programs that LBJ put into place, we started to see a new approach to federalism, where we started to see a lot of powers that were transferring out of the federal government and going back to the states. It kind of happened, during the New Deal, where you saw a lot of programs being pulled from the states and give to the federal government to run. But kind of the opposite happened here. Nixon and Reagan, who are a couple of the more conservative presidents that we've had, felt that the government collects the taxes and then they share a small part of them with state and local governments who are a little bit more knowledgeable about identifying day-to-day needs for that money. Reagan also proposed greater flexibility in use of federal funds to allow state and local officials to exercise more control over the programs and the projects that they run. So really kind of a way of maybe taking some of the powers out of the federal government and giving it back to the state and local governments. Now, we also have a concept of something called coercive federalism, right? There's federal mandates that the federal government will have direct orders to state and local governments to perform a particular activity in order to comply with federal law. No monies are provided, and the state and local governments, as well as at times private businesses, have to comply with this by use of their own money. One of the things that is really a good example of this is the Americans with Disabilities Act. So the Americans with Disabilities Act is a federal law that requires states, local governments, as well as private businesses to provide accessibility for people with disabilities. And it's going to be on their own money, right? So a couple of things that can kind of come out of this is that if states and if local governments and if private businesses don't comply with this, they can face a fine from the federal government. And also they could potentially be looking at a lawsuit. So there's a lot of things that can come in and encourage a state, local, and government and private business to comply with these federal mandates. And the Patient Affordability and American Care Act, the Obamacare, is another one. The Affordable Care Act is also a federal mandate, but we won't necessarily get into that. We'll talk a little bit about that later. But I think the Americans with Disability Act is a very good example of a federal mandate. So we talked about tax dollars coming out, and they come through grants. So we have a block grant, which refers to granting aid of a specific amount of money from the federal government that could be used for a broad purpose. So the federal government will collect tax dollars and then give it to state governments and tell them, you can use it how you want to. And they're used to fund law enforcement, maybe some type of social service, public health, or a community development project. These block grants will have less oversight, and states and local governments will have more flexibility in using these. Kind of different than what we call a categorical grant, right? Categorical grants are grants that are issued by Congress, and they have to be used for a specific purpose. I always like to use the example of Head Start. Head Start was created in 1965 as a summer school program to help low-income students kind of get ready for transitional, kind of that period between preschool and kindergarten, kind of giving them a way to be ready for kindergarten. The federal government provides money to run this program, but it has to be used for Head Start. It can't be used for anything else. So we have a block grant and a categorical grant. So, coming to a conclusion on this lecture video, We've seen different levels of government. We talked about the necessary proper clause. We reviewed the Adam Walsh Child Protection and Safety Act and its tie-in to federalism. We analyzed the different periods of federalism in history, and we looked at block grants and category grants. Okay, go ahead and take a look at the other videos for the week, and we'll see you soon.